Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. We come to you today after another loaded week. The Supreme Court heard 3 cases, including 2 major ones. In today's episode, I'll recap oral arguments from this past week. Before that, let's quickly talk opinions. Before we begin, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundowns. Just search the High Court Report. And if you have questions or comments, reach out via LinkedIn or email, scotus.cases.pod@gmail.com. As I mentioned in Monday's episode, the Supreme Court issued 3 opinions on January 20th. I released opinion summaries yesterday and today. In this upcoming Monday's episode, I'll provide additional analysis. Today, we'll focus strictly on oral arguments. Okay, let's talk oral arguments, beginning with Wolford versus Lopez. Many themes emerge from this oral argument, but I want to focus on 2, the distinction between First and Second Amendment treatment and the battle over historical evidence. On the distinction between treatment, Chief Justice Roberts set up the comparison by first establishing basic property law principles. He asked Wolford's counsel about door-to-door solicitors and political campaigners. Under our law, do people soliciting or dropping off pamphlets have an invitation to enter private property? The answer, yes. Strangers can walk off the sidewalk and go up to your door, even on private property. Roberts then used this foundation to confront Hawaii's lawyer with a pointed critique that Hawaii's position transforms the Second Amendment into a disfavored right. He posed this scenario. It's a clear constitutional right under the First Amendment. If I, as a candidate for office, want to walk up to your door on private property and say, "Give me your vote," but you say it's different when the candidate carries a gun. What exactly is the basis for the distinction? Our precedents talk about the Second Amendment being treated as a second-level right. I don't really see the basis for the distinction. Hawaii's counsel, Neil Katyal, defended the difference by arguing that First and Second Amendment tests work differently under the court's precedents. But Roberts countered, "You said there's no right to enter private property without owner consent." Well, we know that's not a through line because you do have a right to enter private property to exercise First Amendment rights. I don't need a sign saying, "Okay to leaflet here," or "Okay to campaign here." The assumption is there's a First Amendment right. What's the difference between the First and Second Amendment? Justice Alito made the accusation even more direct. He told Hawaii's counsel, "You're just relegating the Second Amendment to second-class status. I don't see how you can get away from that." Alito then posed his own parallel. If a restaurant owner dislikes political attire, could Hawaii require express consent before someone wearing campaign buttons enters? Hawaii's lawyer said that would violate the First Amendment through viewpoint discrimination. Alito's response, exactly. It's a First Amendment violation and a violation of the Second Amendment right that this court protected in Bruin.
Mr. Katyal,
back
you're just relegating the Second Amendment to second-class status. I don't see how you can get away from that. If someone owns a store, or let's say it's a little restaurant, and this person has very strong political opinions and does not want anybody in that restaurant who is wearing attire that is expressing approval of a particular political candidate, that person, the owner of that restaurant, has the right to say, "You can't come in," right?
Yes.
All right. Now, could Hawaii enact a statute that says that if you are wearing the attire expressing approval of a particular political candidate, you can't come in unless you get express consent from the owner of the restaurant?
Again, that's a viewpoint discrimination and prohibited.
It's a violation of the First Amendment.
Both justices established the same point. Political candidates can enter private property without explicit consent, but gun carriers need written permission slips. Same activity, exercising constitutional rights on private property, but vastly different treatment based solely on which constitutional right you're exercising. Second, history. Oral arguments coalesced around two sets of laws, 1771, anti-poaching laws, and black codes. Remember, history proves essential in Bruin because the court established that governments must justify gun restrictions by pointing to historical analogs from the founding era or Reconstruction period that share the same burden and justification as modern laws. 1771, anti-poaching laws involved colonial regulations prohibiting armed hunting on private property without landowner permission, designed to protect crops, livestock, and prevent poaching on enclosed estates. Hawaii cited these laws as proof that requiring property owner consent before bringing firearms onto private land represents a well-established historical tradition dating to colonial America. On the 1771 New Jersey anti-poaching laws, Justice Kavanaugh pressed Hawaii's counsel hard. How does a colonial law designed to stop people from hunting on private estates justify restricting modern Americans from carrying firearms into coffee shops? The justices seemed unconvinced that anti-poaching statutes, focused on protecting crops and livestock from hunters, create adequate analogies for regulating concealed carry permit holders entering Starbucks. Black codes involved post-Civil War Southern laws systematically designed to disarm newly freed slaves and prevent them from exercising Second Amendment rights, often through discriminatory permit requirements and consent rules. Hawaii cited these laws, arguing that even Reconstruction-era legislators recognized legitimate property owner authority to exclude armed individuals, claiming the consent requirement protected rather than violated constitutional rights. The Black Code reliance animated several justices. Justice Alito confronted Hawaii's counsel on whether citing laws enacted for exactly the purpose of preventing someone from exercising the Second Amendment right represented the height of irony. He emphasized that these laws specifically aimed to disarm the Black population in order to help the Klan terrorize them and put freed slaves at the mercy of racist law enforcement officers. Justice Kavanaugh reinforced Alito's critique by citing the court's recent Ramos decision, which flatly rejected Louisiana's historical precedents because they were rooted in racial prejudice designed to prevent Black jurors from having their votes counted. Justice Gorsuch captured the broader skepticism, noting the irony that advocates who normally treat Black codes like garlic in front of a vampire suddenly embrace them when they support gun restrictions. Mr. Cotchill attempted damage control by arguing that the specific consent requirement was race-neutral and that even the opponents of the Black codes recognized property owner exclusion rights. But the justices appeared unconvinced that any part of discriminatory legislation could provide legitimate historical reliance.
These pointed questions from the bench mirror the findings of Daniel Thompson, a legal scholar for imperial law. In his 2026 article, Litigating Originalism in Bruin, Thompson codes the specific ways advocates and judges build constitutional arguments. It sounds like the justices' aggressive questioning here would fall under the bucket Thompson calls methodological policing. Under this framework, Roberts and Alito prioritize the uniform form of the legal test over the specific content of Hawaii's law. They demand a single standard for all fundamental rights and reject any attempt to balance public safety against the Second Amendment. Regarding historical fit, the justices struggled to find what Thompson calls historical to doctrinal rigor in this comparison. Hawaii offered the history, but the justices saw no bridge between the laws of the 1700s and the 1800s and today. The justices viewed anti-poaching statutes focused on livestock as inadequate analogies for regulating concealed carry permit holders in a Starbucks.
I predict Wolford will win and that the court will strike down Hawaii's law. A majority rejected Hawaii's historical evidence, which, as we said, proves absolutely essential in this case. Let's next talk about M&K Employee Solutions versus IAM. In this case, remember, a pension plan changed its calculation assumptions 3 weeks after the measurement date, causing a company's liability to triple. I gave the restaurant analogy. You go to dinner on December 31st, waiter gives you the bill. 3 weeks later, the restaurant calls and says you owe 3 times more because today they raised their menu prices, effective December 31st. This case had an undercurrent of deceit and unfairness, that you can't raise prices after a person ate at the restaurant. IAM came prepared to address this head-on. In oral arguments, IAM argued that the statute contains 4 built-in guardrails, safeguard against deceit. First, IAM emphasized that the statute requires actuaries to perform the assumptions and that actuaries must meet professional standards of ethics, licensing, and practice. Second, IAM stressed that ERISA's best estimate requirement prevents manipulation because assumptions must reflect genuine professional judgment, not arbitrary decisions. Third, IAMs argued that the statute's as soon as practicable requirement protects against unfair delays. Fourth, IAM noted that employers retain the right to challenge actuarial determinations through mandatory arbitration proceedings under ERISA. M&K, of course, vigorously contested these guardrails. M&K made much of a January 24th meeting where the actuary proposed 7.5% or 7% rates, but emerged with an unmodeled 6.5% assumption. M&K said if they lose, they will need to litigate the reason for this reduction. I predict the court will rule in favor of IAM, the trustee, primarily because the statute lists no explicit deadline. It simply says as of. I think the justices will credit IAM's position that as of merely sets a reference point for calculations that are performed at a later time, not a deadline for assumptions. What do you think? Finally, let's discuss Trump versus Cook. At oral arguments, the Solicitor General D. John Sauer argued that the president lacks power to fire governors over mere policy disputes. He insisted that courts maintain authority to police the outer perimeter of any removal, namely about whether the removal relates to the official's conduct, fitness, ability, or competency for the office. He defined cause as conduct affecting an official's fitness or competence for the post, while he noted that some laws require formal trials and that the president's duty to oversee the executive branch permits this specific firing. Finally, he stated that a legal path remains to put any officer back in their post if a judge rules the removal illegal. Justice Kavanaugh confronted General Sauer on Cook's central criticism that their position means that for cause means whatever the president says. This would defeat the central feature of the Federal Reserve. It's insulated from political whims. Kavanaugh said this also means presidents of different parties will fire each Fed governor whenever they get into office there. Let's listen to this portion.
Let's talk about the real world downstream effects of this. Because if this were set as a precedent, it seems to me, just thinking big picture, what goes around comes around. All of the current president's appointees would likely be removed for cause on January 20th, 2029, if there's a Democratic president, or January 20th, 2033. And then we're really at will removal. So what are we doing here? What is, we've started, that's why I started with what's the purpose of the independence and the 4-clause removal. If we accept all these, no procedure, no judicial review, no remedy, that's what's going to happen, I think. And then where are we? So do you dispute that is, the real world effect?
I can't predict what future presidents may or may not do, but the argument strikes me as
history's
On the other side of the verses, Justice Samuel Alito offered a series of extreme scenarios to point out possible absurd outcomes of Cook's position. Let's listen.
Let's take your front line argument first and see how far you're willing to go. Suppose that the office holder was permitted to resign from a previous job under a non-disclosure agreement based on long and egregious pattern of sexual misconduct. That would not be cause for removal.
So what I would say, Justice Alito, is I don't think that would be INM. And so if I'm going to stick to my frontline position, then that would not be for cause. It would certainly be a basis for impeachment. And I think in understanding why we've had INM for at least 90 years.
All right, I understand your position. How about if after the person assumes office, videos are disclosed in which the office holder is expressing deep admiration for Hitler or for the Klan?
I can only imagine where these typos are going to eventually go.
Because your position.
I'm going to stick with my position. Of course, I'm going to stick with my position. And I'm going to say that's an official that would be impeached in a heartbeat. And the fact that they would be impeached in a heartbeat is going to cause them to resign in half a heartbeat. And this has not proven a problem. I mean, for better or for worse, whatever you think of Humphrey's executor, we've had 90 years of.
But Clement didn't budge. He admitted that his strict reading of the law protects even these people from removal by the president. Cook's counsel argued that the law allows firing only for professional failure or crimes occurring during the term of office. For personal scandals, he pointed toward impeachment by Congress. He even joked that he's not trying to be a masochistic, but because that's the result of Congress's judgment about the importance of Federal Reserve independence. At least 3 justices floated the following off-ramp to avoid the questions about for cause removal: to find error because the position required process and she didn't receive process. Don't resolve this complicated question on this emergency record. Kick the case back and let Trump redo the firing, but with more process. From that perspective, the oral arguments gave Trump a roadmap to legally uphold her firing in a way that's free of procedural defects. Here's something I found interesting. Justice Jackson offered Cook's lawyer, Paul Clement, a golden opportunity to attack the government's weakest point, but he declined to take it. Jackson pressed hard on notice requirements. Isn't notice a particular thing in the common law? How can we assume that she's on social media or that posting constitutes sufficient notice? Jackson's skepticism reflected basic litigation reality. You cannot serve legal documents by posting on Truth Social. Police officers can't give you a speed camera ticket by posting it on social media. And to be served with a lawsuit, courts require personal service, certified mail, or other formal procedures with proof of receipt. Why should removing a constitutional officer require less formality than serving a speeding ticket? But Clement declined Jackson's lifeline. He said he didn't want to, quote, resist that Truth Social postings can amount to proper notice. So then, did he concede notice? Nor at all. He instead argued that Cook's notice is indisputable evidence that the president prejudged the matter. Biased decision-makers violate common law principles requiring decision-maker neutrality. Why the concession? Maybe he preferred to not be so rigid as to what the process would include. Sticking too formally to one option may make his position too extreme for the swing justices. Also, it allows him to hammer home that Cook must receive judicial review for the for cause determination. Otherwise, everything is a joke. For cause means whatever the president says. Cook hewed extremely close to the for cause purpose throughout oral arguments. I predict the justices will rule in Cook's favor on narrow preliminary grounds. Their opinion will give the administration another chance to fire Cook. It won't proclaim that this conduct can never qualify as for cause removal. Thanks for listening. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to read rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email, scotus.cases.pod@gmail.com. Talk to you soon.